Welcome to This Explainer. Today, we're diving into a really sensitive and rapidly unfolding legal clash right in the heart of New York. A brand new medical aid in dying law is set to kick in next month, but it's triggered a massive lawsuit sitting right at the crossroads of healthcare access and religious liberty. We're going to break down this impending legal battle totally neutrally, based entirely on recent national news coverage. Our goal? To help you understand exactly what's at stake for everyone involved. To keep things organized, we'll be looking at 4 key areas today. 1. The lawsuit explained. 2. New York State's defense. 3. The legal counterargument. And 4. Faith, vocation, and choice. So let's jump right into Section 1, the lawsuit explained. You might be wondering who exactly is bringing this to court. Well, it's actually orders of Catholic nuns who run facilities for the elderly and infirm. And their concern is absolutely massive. These sisters are deeply worried they're going to face actual criminal penalties if they don't comply with this new state law. They argue the legislation would literally force them to help terminally ill patients end their lives. For these nuns, we aren't just talking about a minor regulatory hurdle here. They view this as a profound violation of their Catholic faith. To really wrap our heads around their position, we need to look at the religious framework driving the lawsuit. Archbishop Hicks outlines the Catholic Church's overarching objection pretty clearly. He says, "We believe that life needs to be protected and respected from conception to natural death." He warns that once a legal right is established to choose exactly when to end life, it creates what he calls a very slippery slope. You see, for the Church, the sanctity of a natural death is a foundational belief, a cornerstone they feel is directly under attack by these state mandates. Which brings us to Section 2, New York State's defense. New York's leadership is definitely pushing back hard on the idea that these religious groups are going to be forced into anything. Defending this historic legislation, Governor Kathy Hochul put out a statement explicitly saying that, while she can't comment on pending litigation, participation is entirely voluntary. She went on to assure the public that religious facilities absolutely possess a clear right to opt out if they want to. Now, on the surface, that sounds like a definitive exemption for the nuns, right? But the real question is, does the actual text of the law line up with the governor's public assurance? Let's find out in Section 3. The legal counter-argument. And here we hit the absolute crux of the legal battle, a direct contradiction. On one hand, we have Governor Hochul's guarantee that participation is totally voluntary. But on the flip side, we have Mark, the lead attorney for the nuns from the Becket Fund. He argues the law explicitly states these facilities have to counsel people about the options. So we're looking at a fundamental disagreement over what the law actually enforces on the ground. According to the plaintiffs, the state mandate goes way further than just a simple opt-out. They claim it requires facilities like the Carmelite Sisters or the Sisters of the Poor to counsel people about their options, to end their lives, and even counsel patients on the benefits of doing so. Plus, they argue the law forces them to let outside individuals into their homes to offer these services and actually stops the facilities from preventing their own employees from participating. The attorney's point is stark. He's saying the law New York actually wrote just doesn't match the governor's promise of an easy opt-out. Now for our final piece of the puzzle, Section 4, Faith, Vocation, and Choice. Beyond all the intense legal back and forth, there's a deeply human element to this dispute. Mother Mary, General of the Carmelite Sisters for the Aged and Infirm, passionately laid out their mission. She stated, "We bring compassion to those entrusted in our care and ensure no resident has to die alone, and this law strikes at the heart of that vocation." For these sisters, their entire life's work revolves around providing a very specific kind of faith-based presence during a person's final days. They argue that forcing them to provide these new options violates the sacred nature of the care they offer. But to see the whole picture, it's really important we zoom out and look at the broader public context. When it comes to public perspective, it's fascinating to note that 63% of U.S. adults do not believe medical aid in dying is morally wrong. That's a pretty significant majority of the public supporting the underlying premise of this kind of medical access. It really highlights a major cultural shift, one the state is now attempting to codify into law. However, the plaintiffs have a strong counter to that majority opinion. The nuns' legal team argues that regardless of what that 60% believes, there are still millions of New Yorkers who want the freedom to choose purely religious healthcare. They point out that patients and families actively seek out these Catholic facilities precisely because of their faith-based approach. The attorney emphasizes that these folks just don't want these end-of-life options presented to them on what might be their absolute worst day. They feel the state is effectively stripping away their right to a healthcare environment completely free from those options. And here's the thing, time is incredibly short to resolve this. The lawsuit was heavily debated on national news back in July, but state Senate hearings on the matter are rapidly approaching this August. And the hard deadline for all of this? The medical aid in dying law officially takes effect next month, so the legal clock is ticking down incredibly fast for both the state of New York and the Catholic Sisters. As we wrap up this explainer, we're left with a massive, pivotal question that we'll all need to watch closely as these August hearings unfold. How will the courts ultimately balance the state's mandate for medical access with the constitutional right to religious freedom? It's a real legal and ethical tightrope, and the outcome is likely going to shape the future of healthcare and religious liberty for years to come. So, which side of the scale will hold the most weight? Keep that question in mind as the story continues to develop. Thanks so much for learning with us today.